Hello, everyone. Thank you for coming to our Zoom meeting. For those of you that haven't been to one, full welcome. For those that have, we may be covering some of the same ground, but there have been a couple of updates as late as today, actually. So we will be updating you on that. Introduction again. My name is Jack. I'm from the Red Union Group. The umbrella organisation, I guess, that provide the back of house to some of these unions. So we've got the Nurses Professional Association of Australia, Teachers Professional Association of Australia, Australian Medical Professional Society, Professional Drivers Association of Australia, and I guess announcing it maybe even first here, we've also been in talks with some police officers from Victoria, New South Wales and Queensland, and it looks like there is a possibility that there may become a national police union join our Red Union umbrella. So exciting, but also sad that it's come to this, I guess. And it's madness in the office here trying to deal with the inquiries coming in. We're trying to help as many people as we can. Again, from the top, I would like to apologise if we haven't got back to your emails. We are trying to answer most of the phone calls coming through, but emails and live chat, we are getting a big backlog. But we've got a huge, awesome team of nurses who've come in here to volunteer their time to help us get through this. So they're just outside here. You can't see them, obviously, but thank you to those people. Separately, I've got Sophia just off camera here. She's helping us moderate. Dr. Tracy Watts as well, our resident scientist, and on the other line, who's also volunteering and doing a fantastic job, I may say, keeping me sane. And on the other line, we've got Miles Heffernan, who is legal genius, industrial advocate, knows this space better than anyone else in Australia. So we are very, very fortunate to have your time, Miles. Okay, so from the top, who can join? Almost anyone can join if you're in the health space. If you're interstate, the Australian Medical Professional Society, they wanted to set up a union run by doctors for everyone. So there is a home there for you, even if you're a wardie, etc. Nurses, we're now national. Teachers, national. So we almost covering the field. Even for those in the police or in other miscellaneous fields, our strategies will likely still work, I think. Well, our concerns about workplace health and safety and the lack of risk assessments and the lack of consultation seem to be evident in most industries. So I would advise you go to our website and just steal some of the letters that we have on there and use those to your advantage. Make good use of them. So in that regard, what do you do if you are only tuning in now for the first time and the deadline is AMPS for Allied Health? Yes, absolutely. amps.asn.au. If you want to see a list of the unions, go to redunion.com.au and there's a list of all the unions we have operational at the moment. So if you're working to a deadline tomorrow of the 30th, I know there's a deadline in New South Wales, and I think there's a deadline there's a deadline in Queensland tomorrow. What do you do? So on our website, there's stage one. So if you go to the NPAA, for instance, or whatever the relevant union is for you, on the homepage, there should be a WHS info or concerns, WHS info. If you click on that, it's got a number of steps. Stage 1, 2, 3, and 4. Stage 1 is to get an exemption. If you believe you have a legitimate exemption and you can justify it, we absolutely believe in that. Doing that is the first step, and that is separate to also your workplace concerns. We would advise you to take step 2 as well. Miles will have some more on the exemption stuff, which is an exciting development. Stage 2 is to send off an email to your line manager requesting a risk assessment, and there is a template on the website, a risk assessment that risk assesses the impact of COVID-19 on your workforce at a ward level or at a police station level, and it needs to be that granular. So they can't just say they've done one for the entire workforce of New South Wales Health. It needs to be that granular. And in that risk assessment, they will have risk assessed and said that vaccination, mandatory vaccination is the only way that we can mitigate this risk. and then there are risks that come with the vaccine, they should explain that in that process. There's also some positive developments with rapid antigen testing being granted by the TGA today as well, but I'll get to that in due course. Stage 3 is in go. So these steps will need to be done pretty rapidly if you're joining us for the first time. Stage 3 is then you'll have to become a member. Go to your dashboard, fill out a form, which will add you to our CRM or our client relationship manager sort of platform, which can then track your case. And you will get a form which you will fill out and download from the website, which you will then send off to your manager stage. I think that's a stage 3 letter appointing us as your advocates to deal with this issue. And then stage 4 will come in due course. So if you have any questions about that process, please get in touch. But it is the process that is the country over if you are having these issues. So please stick with the plan. I see some people are saying they try to get through to us today. Again, all I can do is apologise. We're putting on, I think we've got 10 volunteers coming in tomorrow, and we're putting on 4 casual staff to come in and try and help out an extra 4. So I think our team's going to be close to, beyond 40 or something. So it is getting a little bit out of control. I'm sorry, but we are trying our best. Bear with us. But Miles, would you like to give us an update on what's happened, maybe even in the Fair Work Commission recently with Deputy President, and then also, rapid antigen testing? What does that mean? And is there an avenue for Queenslanders with this exception that you found?
So good afternoon, everyone, and I would be most curious to see the difference in appearance between now and 3 weeks ago as these inquiries come in. Echoing what Jack has said, there's been an enormous intake of concerns. And let me say from the outset, it's a very strange situation, isn't it, where the bosses set an arbitrary deadline, they do not want to move from it, and then they threaten your pay, or in some cases we're hearing today, your jobs, because you have some good faith concerns. So right from the outset, if you don't have any good faith concerns with relation to your risk assessments, then don't ask for them. If you don't want to apply for exemption because you don't believe you qualify, or your doctor or your religious leader doesn't think you qualify, then don't apply for one. The purpose of today is to talk to people who are genuinely concerned about how this direction kicks in, or directions in the different areas, and your work health and safety, and the overlay between a public health directive or an employment directive. Can you all hear me? I'm seeing a couple saying they can't hear it. Yep. Okay. Now, fun fact as an example, we got a risk assessment back from one of the big hospitals. I'm not going to tell you which one, because it's been sent off to council today as part of a broader strategy. But if I told you that the steps were that if there was not consensus on a risk assessment, then that triggered an escalation process internally, not after the Department of Health, but each hospital. And of course, each hospital is its own separate statutory body. There's 16 statutory bodies that are in there, and its process is to go internally because the boards control the hospitals. And rather than them say, not only do they not have to give them to you or take it up with the health directive, quite the contrary. Helpfully, there's a little flow chart of what's meant to happen. But as I said, it's not. We don't need to telegraph it more than that, except to say that even the hospital's own documents, when they have been provided, show that nurses and other staff are being neglected. All we've asked for is risk assessments in a fair time, and we've been asking for 2 weeks. Now, let me deal with the first part. Once there's a risk assessment provided to you, then there's an obligation to consult. We've asked and asked and asked, and as some of you have noticed in the comments already, they're ignoring you. That's a matter for them. These guys are setting rules that they're saying are enforceable, and we are saying they're not. For example, all health directives, health employment directives, need to be read in conjunction with other laws. And if it's a private sector employer, the Fair Work Ombudsman has made it clear that a mandatory direction is not acceptable. Deputy President Dean of the Fair Work Commission, in a withering dissenting judgment, made the following point. Blanket rules such as mandating vaccines for everyone across a whole profession or industry, regardless of the actual risk, fail the test of proportionality, necessity, and reasonableness. It is more than an absolute minimum necessary to combat the crisis and cannot be justified on health grounds. It is a lazy and fundamentally flawed approach to risk management and should be soundly rejected by courts when challenged. That's Deputy President Dean of the Fair Work Commission, who is was appointed, incidentally, by the current government. And so the argument that she's some sort of lefty warrior would be misdescribing completely. She's incredibly impressive Deputy President of the Commission, and her judgment should make everyone pause. So knowing that you've got as many people as the Deputy President of the Commission are saying this is the right approach, and the blanket components don't apply to a standard rational assessment of risk, and in circumstances where your stage 1, stage 2 and stage 3 letters have been ignored, woe be told the employer that would then want to press ahead and fire you. And that's why you need the support that you've got from your unions. So now that we understand that there is the groundwork has been laid, and talking, I appreciate there are other people in line, but for the purpose of Queensland Health employees, Dr. Wakefield's letter yesterday made it clear that you need to apply for some exemptions. I am very pleased to say that we have a document that will be out soon, which will assist you for that under the concept of exceptional circumstances. That's not an exemption for religion, not an exemption on the basis of any contraindication of the vaccine, but something that will assist and comply, as we say, with the policy. And if that's something that you are open-minded to applying for, it needs to be applied for before 11:59 and in writing to your manager. But Jack will go into that in a little bit further detail, and there'll be some more resources. Now, what it means is that your employer is setting this deadline. Your employer is making these directives and saying that they sit on their own, and your unions are saying they don't. And for what it's worth, we agree. One group has already lodged a Supreme Court application for a judicial review on the directive. And in any event, the words on the page of the directive make it clear that it is read in conjunction with other laws. So don't listen to your employer if they just tell you you must follow the directive and that's the only component to it. But of course, that's why you do need the support. And yes, because of the compressed time frame, that does mean it's meetings like this that we have to deal with while we manage it. So you've got the Fair Work Commission, albeit in a dissenting judgment, but a very senior member of the Commission agreeing that this is the right approach and calling it out for what it is. You just want to be heard. We've offered to consult repeatedly and they've ignored you. That's on them. And so be careful, anyone that's saying that it's not. And separately, and bearing in mind with hospital boards, they run your hospital, not the employer and the Department of Health are different beasts. And so it is not for your hospital just to flick it up the road to the Department of Health. Your hospital is its own organisation. So that's the overview on the safety components. Now quickly turning on the religious exemptions. If you have a genuine religious doctrine and your pastor, your rabbi, your mufti, etc., your priest is in agreement or it is part of it and writes the letter, then that's important. But don't act in bad faith. Don't make it up. You'll get yourself into trouble. So, and you don't need your letter from your doctor and from your spiritual leader to make the application, but you need to get your skates on. So if you do have and want to exercise a genuine religious exemption anchored in the religious doctrine and will be supported by your spiritual leader, please apply, even if you don't have a letter, because you will need to do that before tomorrow. Now, the overlay of religious exemptions are more of a challenging beast than others. And obviously, if you have a genuine medical exemption, such as a contraindication, then they should be applied for as well. And there is a third form of special circumstance that we are proposing that may be of use as well. So that's the sort of key overview. And the fact that, as Jack said, that the rapid antigen testing has now been approved by the TGA, that allows for the employer to engineer out the risk by testing not on the worksite to ensure that you do not have COVID. And that was referred to directly by Deputy President Dean in her decision as well. I'll leave it there, Jack, unless you wanted me to.
Yeah, no, wonderful. That's great. Thanks, Miles. scooting through these questions. I have completed step 3. I'm waiting for a reply from my line manager, HR representative. Given the direction from Dr. John Wakefield, the DG, to inform my line manager of any intention to receive the COVID vaccination, do I ignore this or not? I guess that question comes down to and another one here. I've uploaded my vac status already. I didn't check the steps first. What do I do now? Do we have to comply with a direction to manager calls up and says, hey, just want to know whether you're going to comply by the 30th or not. I'm doing my rosters at the moment.
In about the next half an hour will be a supporting materials for an application for an exemption for special circumstances that fits a number of categories outside of religious and medical. If anyone believes that that is something that you would like to apply for, you need to do so prior to 11:59 p.m. tomorrow and notify your line manager in writing. It's very clear. It is the line manager in writing. So yes, this is very specifically for Queensland Health employees. For others that are providing your exemptions, that there will be slightly different tests. I just want to touch on the comment that was just made that you've been given an extension for a month. That is not what the direction says. Dr. Wakefield's clarification was the application needed to be in by tomorrow at 11:59, including a written notification to your line manager, and it can take up to a month for that to be assessed on an individual basis. Please do not think that you have another month, because you definitely do not. You must make your application by tomorrow at 11:59 and notifying your line manager. And I appreciate there are other people online, Queensland Health employees. This is a critical deadline and you must pay attention to it.
Wonderful. There's a question here. I think this was relevant for those tuning into New South Wales. I think we might have got lost in communication this morning. And they thought our instruction was do not return to any more shifts tomorrow after this Zoom meeting.
They probably meant the first.
The first. But yeah. So Miles, just to clarify, at all times we are ready, willing and able to work. This is the employer telling us not to go to work. We are not withdrawing labour in any way, shape or form. But the risk is, or what we have to be wary of, is we have to follow a workplace direction. Is that right, Miles? So if they tell us explicitly don't come to work, we don't come to work. If we turn up, if they're silent on that, we turn up to work and they say go away, we go away.
Exactly correct. This is not a place where you storm the fort, but at the same time, we are ready, willing and able, and we've expressed that a number of times. If any of you are in any way clarifying, we need your line manager to write to you and explain to you that based on your situation, they don't expect you to turn up and that you stay away. And if you are told then to stay away, you must, but we will assist you in doing it. That might mean that we are making an underpayment of wages claim on your behalf or some other industrial dispute to recover your losses or other legal action, but you must not attend a workplace if your boss has told you no, because then you've done everything else by the book, and then a boss could use that in an unfair way to actually say, well, that's all fine, but I'm firing you because you turned up when I specifically told you not to. So be very careful about that, and you clarify, make sure each of you, a blanket letter out to everybody, do not show up, has grey area. Your best bet is to clarify with your line manager, are you saying based on my circumstances, despite me being ready, willing and able, that I cannot come to work? And if they write back yes, then you must not turn up to work.
Wonderful. HR has told my NUM to get me to fill in an annual leave form for a month at a time. Is this what we should be doing?
And I know this. I've seen those ones on private. We will get to the public. That's about the public ones right now. We will get to the private stuff. But yes, in answer to your question, Jack, we aren't withdrawing labour. Your annual leave is designed for you when you are wanting to take a holiday. Why is your boss telling you to take a holiday when you're ready, willing and able to work? That is your asset. That is time to spend with your kids. That might be a time when you've booked a holiday, once we can remember when it's time to travel again. So what it's important about is that you do not accept that your boss you should draw down on your asset, your safety net, whether that be your long service leave or your annual leave or other special leave that you may have accrued. It's yours to use with your family.
Excellent. I'll just, Angus has just joined us. He had an ABC radio interview this afternoon. Also, for those who are in Brisbane, we'll be on channel 9 and 7 today. And I think on channel 9, there may even be a nurse speaking anonymously on the record about things that she's been seeing. So it might be of interest to some of you from Brisbane to tune into channel 9. Otherwise, I think they might post it up on social media, but we'll see. You never know with the media. Can I just say how disgusting I think this comment is? Should add, if it was mentioned in the Metro North hospital cast today that line managers feel bullied by staff members sending them requests for risk assessment. I mean, don't get me sorry. That's.
I just need to clarify. Are they going up to the line manager and shoving it in their throat like this? In which case, that might be a fair basis for it. But if you're emailing your boss to ask if your boss is adequately taking care of your risk in accordance with the Work Health and Safety Act, that's not called bullying.
I mean, yeah, people have an obligation to look after their own safety in the workplace under the Workplace Health and Safety Act. It is simply complying with the law.
It is one of the few areas of law that is absolutely not open to any delegation, right? The hospital board that you work at is different to your legal employer, and it is up to your board, of the hospital board, and the hospital health service that you turn up to every day to protect you, separate and in addition to the legal responsibilities of the Department of Health for your separate workplace health and safety obligations.
My partner really want to join. Do you mind if I record? No, that's fine. We are also recording and will likely post up on social media for those who couldn't make it. I need the AMPS step 3 and 4 forms. I have not sent anything through as I can't get through. So I believe we'll email out some instructions to our AMPS people. That has gone out today.
Yeah, if you check your inbox, there should be stage 4 instructions, which all links to the same page. I think what the confusion might be there. I see you reference nursing forms. It's the same body you're appointing for both. So.
And there was another question about there not being any teaching forms yet, but they are coming. I think there was just a more pressing deadline with the medical stuff at the moment.
So. Same with interstate nurses as well. Queensland and New South Wales are tomorrow, but the other states will roll out.
And other than WA, there are national occupational health and safety laws. So while a section here or a section there might not be consistent, the underlying principles remain identical, that your boss must consult with you about the risk assessments, and risk assessments are conducted under an Australian standard. What that means is that it's not a something they can just whip up, and then once you've got that document, you can then consult with your boss. Banks use an Australian standard to assess risk, and it is the same methodology, whether it be for money, corporate risk, or safety.
I'm a New South Wales employee who had received a response to the risk assessment saying it's not required because of the health order.
Magic.
Yeah.
Right. Oh, good. I didn't realise that Mr. Gazzard had the power to override the Work Health and Safety Act. That's fabulous. Or is it Hazard actually, is it? Irony. No. So yes, there is a ministerial directive, and just because the ministerial directive is issued doesn't make it so. And remember, it is your employer, both private and public sector, that is responsible for your work health and safety, not a minister. In fact, the minister is indemnified, as it turns out, and the Crown protects him or her from that role as part of the ministerial privileges. Your employer is responsible. That's why under the Fair Work Act, was not amended, because the federal government had an opportunity under the Fair Work Act to put this in, and they specifically said no. If the Fair Work Ombudsman, as the cop on the beat, said that it can't be a mandatory direction, it would be highly unlikely to work, and it's on a case-by-case basis. So what do you know? Where's that case-by-case basis come from? What's that thing called, Jack? Risk assessment, right? And that's how you do a case-by-case. So any boss is suggesting to you that they don't need to consult with you, well, they're telling the Fair Work Ombudsman they're wrong. They're telling the federal government they're wrong, and they're telling the people that wrote the Fair Work Act they're wrong, and your state acts. It's nonsense. They must consult with you. Now, it might be that they take a step to keep you away from the work site. That's entirely different from their obligation to consult with you on the risk assessments. we are weighing up on one breath, not potentially getting paid, which of course could be catastrophic to your family situation, versus being fired or being put in harm's way in another. And I appreciate some of these are individual situations, but it is incumbent on your employer to consult. And I've got to tell you, we've got 12 risk assessments back out of, I counted them for the as part of the preparing the brief to council. There has been over 900 emails go out with relation to risk assessments at level 3. So that's once they've come to us. What it means is that your level 1 and level 2s that have also been ignored, your employer just cannot do it. And the audit trail for that is something that they are absolutely on notice about, that if they continue to ignore them, then they are putting themselves at the risk of having that looked at by a court or commission of competent jurisdiction.
Maybe this isn't a question, but just a note, because it's interesting, and I would advise you to keep an eye on it. But Coast Life Midwifery has said here, would it be wise to apply for exceptional circumstances, not religious or medical, based on the fact that we've not received a risk assessment within the time frame?
Who asked that question?
Coast Life Midwifery.
Well, Coast Life Midwifery, if you've got any spare team, we would love you in the office, because I absolutely agree with your reasoning, and we're a little stretched. And we absolutely agree that that could in fact be a very good faith basis for exceptional circumstances, as for example would be a forced medical procedure that didn't have fully informed consent, which Tracy had to teach me about this week.
I just note a comment here. Brad Hazard indicated, not budge, there's only 2.65% of New South Wales staff unvaccinated. It doesn't feel like this will impact the system. I can't comment on that. I'm not totally aware of the New South Wales system, but I will say this in regards to Queensland. My goodness, today the Courier Mail said there were 10,000 or over 11% unvaccinated in Queensland Health. I say they have no idea how many people are unvaccinated in Queensland Health. The deadline isn't even until tomorrow to have submitted whether you're vaccinated or not. I say that perhaps they don't even know themselves. I say that it's perhaps even more than 10,000 people that haven't been vaccinated. But regardless, it seems like there was some big cast went out today in New South, in Metro North, one of the hospital systems, saying that they're going to terminate people if they do not comply. A, Miles, I'd like your feedback on that. And B, then sent out subsequently to that bidcast a few hours later. Oh, congratulations. It's fantastic. We've had 6,000 nurses vaccinated today alone.
Okay, so there's quite a long-winded answer to this, but first of all, let's go to the Brad Hazard one of 2%. Fabulous, because then they can risk assess with a 98% vaccination rate. The simple arithmetic of that means that, in fact, the compulsion and the mandatory rule may, in fact, need to be reassessed with such a wonderful population. Secondly, on the other side of the fence, this is like a forced strike. If you weren't happy with your conditions and you withdrew labour, you would be in trouble. Your boss is forcing you to have to withdraw labour when, excuse me, you want to come in and care for your patients, support a health environment, support an education environment, support a police environment. So don't stand for that. It's up to them to do that risk assessment. So yes, absolutely press them on those risk assessments and press them on their reasoning. And that reasoning must change as the vaccination rates change, right? That's the whole point, is they then reassessing the risk. Now, the other risk assessment is that if sadly they do kick a bunch of people out, which we don't want, then does that mean that other risks are then made, such as other risks to patient safety? In that on one breath, they then got to weigh up the risk of this mandatory rule and the benefits versus the consequences. And the other side of it, which is good people, good nurses, good teachers wanting to turn up, wanting to help, but can't, and what are the consequences of that? So that's all part of the risk assessment, but unfortunately, they haven't been kind enough to share those, despite that being the law, except on 12 occasions. And I like that one of them was dated April 2021, before there were vaccines even considered, but yeah.
I'm in Victoria Education. We've been advised to take privacy of medical records. What should we do with, I guess, uploading that? Is it a better path to do this risk assessment? Well, I guess the concerns are yours. You do have a concern about risk assessment, and you do then separately have a concern about privacy of your medical records. Well, then there are two concerns that you have, and you could escalate both of those concerns through your workplace. My understanding, Miles, is we may have a position on the privacy of records tomorrow.
Well, if you aren't, we have the advice is that there's no concern of privacy if we're not uploading the record, because we haven't got a medical record to upload. Like if you haven't got, if that's a distinction, if you've had the first jab, if you have, but you've still got concerns, and there are a cohort of people who've had the first jab but are really upset that they were coerced. The privacy rules do apply for that cohort. For people that don't have any of the jabs, then there is no privacy concern, because we don't have a record to upload, and so there's no need to attend to that, because it wouldn't be bad faith. Now, I saw a comment before on InterStress. If you go and tell your employer that you have no intention of ever getting the jab, then you shouldn't be on this call, because we aren't here to not have a rational conversation. We're here to assess risk, and I don't want to be tough about that. But this isn't a place where we can dig our heels in and just go, no. We are genuinely interested in what the boss has to say about our risk. And some of you, upon seeing that, might go, there's my sleeve up. Others might ask for any questions. But if you've got a hell no, it won't happen position, then of course, if your boss was to see that and say your request for risk information is actually a trick, or is misrepresenting what you actually believe, they may come after you in an entirely different way. So be very, very careful about having a public or even a private hell no position, because we're here to consider health and safety, religious exemptions and other exemptions, and your human rights.
Just off topic a little bit, but this is a nice segue to this question. My line manager stated that the Fair Work Commission found in favour of the employer recently. So
Yep.
Miles, do you want to just explain that case, because people may not even be aware of the facts of the case, but there was a recent Fair Work decision that was quite pivotal, and you referenced the deputy earlier.
Be prepared for something.
Dixon about the local member about their care for their constituents. Now, the decision on a 2-to-1 between was about a vaccine that was not a COVID vax for a start, and they weren't happy with the medical evidence. And so while they made some broad references to it, I might just quote from Deputy President Dean, where because of the unique nature of that case, where normally a full bench decision would bind the lower commissioners or the single member commissioners, she says as her final paragraph, finally, all Australians, including those who hold or are suspected of holding anti-vaccination settlements, are entitled to the protection of our laws, including the protections afforded under the Fair Work Act. In this regard, one can only hope the majority decision is recognised as an anomaly and not followed by others. That's a nice way of saying, or actually a pretty blunt way of saying, that that particular case turned on its own facts. It doesn't necessarily bind the local, the single member commissioners. It had very specific information in it, including questions about the quality of the medical evidence and the true motivations of the person that was the applicant. So, and again, each case will turn on its facts. Any employer that says that's a green light, that they can just mandate it, well, the Fair Work Ombudsman doesn't agree. And so, but that said, if you don't meaningfully engage with your employer, you might find yourself in hot water.
So is it unfair to characterise a case as this? The two decisions that held today basically said this is a person who refused the flu jab. There was some issues about that person, saying I can't get it for whatever reasons, and there was evidence problems there about producing it. And then also was asked sort of as an aside, well, would you also get the COVID vaccine? And then they sort of said, oh, well, I'll wait and see how that plays out and whether it gets approved or not. And then the two dismissed it as saying, oh, well, they sound like an anti-vaxxer.
Look, that I won't speak about the majority decision in broad terms, just simply because you appear before these people and there's the decision stands on itself. What I will say is that the decision was following a line of reasoning that it's always a lawful order of the employer. Now, this applicant did not assess the risk and did not ask the employer and did not engage with the risk assessment process. I guess the biggest thing here is we had a gun put to our head for this 30th of September date when the employer hadn't discharged its obligations to risk assess. The big crime in this, or the big frustration, is that I expect there are buckets of you out there that, upon being meaningfully engaged with, would have considered those risk assessments and might have agreed on a path forward, might have waited for a particular vaccine, as is some, or might have proposed some solutions, including this rapid antigen testing. So, but this decision was, of course, made prior to the TGA making a ruling on rapid antigen testing. So, it was a moment in time case, would be the way I put it, on very specific facts, and no employer, private or public, should be emboldened that this gives them a green light for mandatory vaccinations.
I'm a New South Wales health employee. Just like to understand, would you recommend us sending off these free templated letters in regards to informed consent, economic distress, and the Privacy Act? I'm worried if it backfire, can it backfire, or is, this discussion in good faith?
If you are a member through the multiple unions that are covered by the Red Union team, there are processes around those that have been endorsed and been backed up by legal advice. As long as you're acting in good faith and genuinely believe what you're putting to your employer, then absolutely. If you don't believe it, then you ought not to. I did see another law firm mentioned. There are a number of really quality law firms out there doing some exceptional work. If you are on their books, you should work with them. There is some collaboration between different law firms and different people. It's not for us to say who, but what I would say is that your first place to go, if you are represented and someone's given you a template and you're a client of theirs, then you should take the advice from the place where you're a client. To the extent that you are a member of Red Union and also a client of a law firm, and there's inconsistencies, give us a shout and we'll see what's going on. Otherwise, you're ably represented.
I've already indicated I'm waiting for Novavax. Do I still send the risk assessment? I would, if you have concerns about that, then yeah, I'd send off the risk assessment still.
In New South Wales, I don't know where you're from, but in New South Wales, some employers are accepting that as a fair compromise, but are requiring you to be bound by that you will get Novavax the moment it comes in. So I don't know where that person's from. That may be a very reasonable area, but we would need to understand why you've formed the view that Novavax is for you and what science is on. And the least we could do is give your employer that information and allow them to consult with you and to risk assess Novavax and take it from there.
Angus, one for you. Who do we put in the delegate box on the template letters?
So that section is really if your original risk assessment has been forwarded up to HR or some other staff members. So put the your line manager in the to box or whatever the email section is, and then put the other delegates that you've been forwarded to in the delegate section.
All right, good question. I sent 3 letters and the company never replied. I just got my termination letter. Please get in touch with us immediately.
So anyway, I saw another one say they got terminated 2 weeks ago. In most jurisdictions, there is a 21-day maximum window of opportunity. That means that if you got fired on the Tuesday, the clock ticks from the Wednesday, meaning the last day to file would be the Tuesday in 3 weeks. Absolutely essential that you get some advice beforehand. And if you did exercise those safety rights and you got terminated, and you, depending on the jurisdiction you're in, you could have a multiple range of cases, and it's absolutely essential to act in that 21 days. And I appreciate that I'm now going to say something that might get me in trouble with Jack and Angus. Can you please put in your subject matter of the headline, or when you send it to the member support, 21 days, right? So that we can sort that if you're in that situation, please, so that when you're asking for help. And now, if you've been fired after sending those forms off, we will mobilise quickly.
And Miles, if that person is a member of the Red Union Group, obviously we will cover that as part of the membership, and we will take that matter on and progress it legally. But if they are not a member, how do they get in touch with your organisation?
Pre-existing matters, we have we also will give you a free case assessment as part of that, and we have a network throughout. Well, obviously a lot of stuff we do nationally, and we also refer on to other lawyers as well as needs be as part of the network.
Okay, great. So yes, send an email through to us and we'll escalate it. There's a lot of questions coming in about the latest directive from John Wakefield saying, maybe subject to the Public Service Commission directive, disciplining Queensland Health Policy E10 discipline. What does this mean for us then? What can they do to us? I'm fairly certain they mean termination. I think there has been termination bandied around a little bit.
His Honour Justice Bond, in a case called Worth and Mackay Hospital and Health Service, took a deep dive into E10. One of E10's critical functions, which His Honour said was the minimum standard, or was it required natural justice? And the very first stage of E10 is management action. That is what can be dealt with at a local level and what can be spoken about. And that the delegate must consider all factors before issuing a show cause process. Now, Dr. Wakefield has used very soft language there, using the word may after the 31st. I don't propose that you play a game of chicken though, and that we meaningfully engage with those issues so that there can be no wiggle room. The Deputy President Dean in the Fair Work Commission referred straight out to the threat of termination in the absence of a vaccine to be a coercion that also was inconsistent with Australia's international human rights obligations. I don't want us to get into an esoteric human rights debate, but we are dealing in a major area of law, and Queensland is now, through the Human Rights Act, has some other protections. I don't propose that we hang our hat on those though. What we must do is meaningfully engage. But that document, if I may free range, Jack, and sorry, is actually, I think Dr. Wakefield is begging for exemption requests. I think Dr. Wakefield realises that good nurses want to care for their patients, and that was a cry out saying, for the love of God, please apply for an exemption. So we've got a month to sort it out so I can crab walk away from this ridiculously misconceived health employment directive that was done prior to nurses and other staff being consulted with by their employer and by the hospital they work at, safety people. Sorry, rearranging.
No, very good.
Good if you're listening. If I'm wrong about that, my apologies.
I've got a note here about volunteers. Yes, absolutely, volunteers. Please send us an email with subject in the subject line volunteer. One of our team will be able to get to you. In the second letter, do we amend it or send as is? I don't work with patients, and I do. And do I remove the pass about risk assessment that I haven't received it? I mean, it's a letter coming from you, so over to you. It's a template. Try to get through them, so you can amend it if you see fit, but it will likely work as is anyway. Please post your website down and to load the letters. First time here. I just did comment down below. redunion.com.au is a website that then has a list of all of the various unions in the Red Union umbrella. Select a union that's relevant for you. Whether you're if you're in the medical space, AMPS, interstate, NPAA might be relevant if you're a nurse, TPAA as a teacher. There is even talks, so maybe now's here, we are doing the police, potentially even a miscellaneous workers union, but on that redunion.com.au website, there is a expression of interest form. And if we get enough people expressing interest in setting up a union for a relevant industry, well, that's, I guess, what we are dictated by, and we'll get a group of you together and show you how you can form your own union, and away we go.
Now, I see a couple of ones that popped up, and sorry for jumping in. Apparently there's some industrial action on Friday. I need to absolutely stress, industrial action can only be approved by the relevant commission, being the Industrial Relations Commission or the Fair Work Commission. I don't know anything about it, and whoever's advising you to take that industrial action, you should talk to them. I only express massive caution that here we are doing the right thing in good faith, trying to negotiate, understand our risk, understand the extent of what our exemption rights are, understanding our privacy rights and understanding our human rights. and being shut down by an employer. Now, I am very concerned at the idea of the withdrawal of labour, if it is happening, because you might find yourself in a lot of water. But also, as I understand it, we all give a shit about our patients and our students and our members of the public. And the last thing we want to do, because somebody else has drawn a line in the sand, is to withdraw labour and in essence put us on a reverse strike. So be very careful about taking industrial action. It doesn't seem like the right way to go, but I don't know about it, and you should take it up with whoever's advising you, but go in with your eyes open.
Yeah, I think what my understanding of what may be happening, there's various groups of nurses doing this, is if they are locked out of the workplace and they can't turn up to work on Friday and they're in their own time then because all of a sudden they have plenty of spare time on their hands, I think they're going to gather in Brisbane City Hall for a candlelit vigil because they will be worried about those patients who won't be seen to.
Oh, that's not industrial action. That's beautiful, and more power to you. That's a very respectful and decent thing if you have been locked out of the work site. If you are able to work and you're to duck off and do that silent vigil, you could find yourself, and I appreciate this is a legal position, Jack, in more shit than Flash Gordon, right? So only do that if you have been locked out of the website. And for those of you young, Flash Gordon is for old people, so don't worry.
Yeah.
I can go to work on Monday without being vaccinated, but I need to wear a mask and I need just an exemption, which I've done. Okay, great. Yep. We only hear about medical exemption, religious exemption only in America. I believe the religious exemptions are different in each of the states, whether they exist or not. I know in Queensland there are religious exemptions, but as Miles was saying, just make sure you stress test that before you submit it, because you will likely have to give evidence that your local pastor or priest, etc., is of that view.
They would actually have to give evidence, Jack, so they would be signing it and they could be called upon later on to give evidence under oath. So, and as they're a pastor and their oath that they would be giving would be on the religious book for which they've dedicated their life to, you need to be, quote unquote, and sorry, damn sure.
Yeah, I just got a message here directly. There was a staff forum today in X Hospital in Sydney. Director of People and Culture said there's only a small number of staff, not vaccinated, about 100. That includes 2 hospitals. There's 230 public hospitals in New South Wales. There could be as many as 11,500 unvaccinated staff still across the state. Look, that's probably in line with where I'm sitting with this too. I think there is a huge number out there. But, you know, again, it comes down to the individual workplace and risk assessing them and rationally assessing risk, and they haven't done that. And if there is only a small group in that hospital, as Miles was saying, well, that needs to be taken into consideration. But it's amazing the amount of backflips, mind games, all this tricky, poor faith behaviour being exhibited by employers trying to coerce people and bully people into getting the jab without telling them how risky it is or risk assessing what it is in the workplace without discharging their workplace health safety obligations. So I just like that on the record publicly. But
Fancy barristers often use the phrase that you're foisted on your own petard, which is a nice way of saying that you shoot yourself in the foot, but it's done by fancier people, right? If they're telling you that there's only 100 people left, and we've got people like Tracy on the team, right? And let's have a look at the mathematics of that, right? If we then actually run the risk assessment on that, if they're boasting and bashing their chest saying there's only 100 left, well, it doesn't sound like then the risk assessment they did that everyone is exposed will be as it was. They've achieved well beyond herd immunity, and so they'll obviously need to risk assess that. And of course, that approach may change. So whoever's heard that posturing and the chest beating, get your pen out, write it down and say you've got a contemporaneous note. We advise all clients when writing a contemporaneous note, do it without consultation with another person. Close your eyes. If your drink is a cup of tea or a cup of coffee, don't be distracted. Think of where you were, what time of day, what room you're in, what was the weather like, what were you wearing, what were they wearing, and write it down. Hold them to that.
Well, I think that's just the general comments that the government are making. I was just on the radio then, and they mentioned the number of people that were concerned about this that was smaller than the amount of cases we've got in that room. So I think there's sort of what's happening publicly, and then
No, yeah, just lies. But anyway, that's there. This message, oh God, this is heartbreaking. I have been terminated already 2 weeks ago. I'm needing advice as to what to do now. I'm a member of the New South Wales Nursing Union. They're not supporting myself. They can only assist with an unfair dismissal process, which I might add, they say I'd most likely get nowhere with.
Deputy President Dean, who is a New South Wales decision, made a critical point that may give rise to under claims under a Disability Discrimination Act. So depending on whether you're a public sector or private sector employee, you might be able to go to the Anti-Discrimination Board. You may also have a general protections claim, because under Section 341 of the Fair Work Act, it does enliven the relevant state laws discrimination policies. You only have the 21 days. So there are a number of causes of action that can be done beyond 21 days. It is much better to do it within 21 days. The unfair dismissal regime is a regime, but wherever possible, we'd like to get in prior to you being terminated. But as Jack said, as heartbreaking as it is, let's have a look at your case if you're a member, and if not, we can deal with how we deal with it again.
Can you comment just to double back? So for those in private general practice, so those in private hospitals, they can still, the risk assessment stuff still stands, right? The advice that we've been giving is essentially.
Absolutely, and nearly all private hospitals have enterprise agreements that have very good disputes clauses. Depending on the construction of that disputes clause, it can often allow for a dispute that deals with things such as being a full-time employee. So if you're being stood down, for example, well, then you could raise a dispute under that. Secondly, they have status quo clauses, meaning that that you may be able to put a prevention to any swift and mean action of termination. Thirdly, they have arbitration clauses, meaning that it might be something that the independent umpire can look at. And fourthly, some of them have very broad disputes clauses that deal with, excuse me, any quarrel in the employment relationship whatsoever. So if you're in the private sector and you are being thrown around, the first thing I want you to do is have a look at your enterprise agreement, go to the disputes clause. Once you've got that in your hot little hand, send your member support line. And again, if we've got an imminent risk at the moment, you know how busy everyone is, please understand that it may take, if it's not an immediate one, it may need a couple of days for us to get in.
I'm an AO at Queensland Health Community. Would a risk assessment still apply? Yes, applies to. I've been dealing with a lot of people, a lot of industries in a lot of states dealing with this issue, and I can almost tell you it applies almost everywhere. But I'd ask for the risk assessment first, and then if you do get a risk assessment, we will consider the risk assessment and work through that process with you. But I just have not seen an adequate one yet. Good question, Miles. What if you're casual? Why don't they just not give you any shifts?
Test for if you're exercising workplace rights and you're taken off the roster is you're still financially injured or had your role altered in a prejudicial way. So if you've been taking the risk assessment process and they've refused to engage with you and then strip you from the roster, it might be something that would have to be the cause of either a general protections claim, it may be an underpayment claim for another area, it may be a discrimination claim. And if you're in the private sector and you're asking them to seek compliance with the law following the Royal Commission into Finances, there's also victimisation now in the Australian Securities and Investment Commission laws, which in essence mirror the state-based whistleblower laws. So again, your employer might be brave in thinking you're a casual, we could just take you off the roster. That very well may not be the case, although it is likely they will stop paying you immediately to try and put you to hardship, and that's where you need to get member support.
This is sort of coming up a fair bit. I've sent emails to the company or to the employer, and they have never replied. What would you recommend those people do? There's just nothing coming back.
So when we were kids, right, now parents said you must do something, right? And we always did it until we were about 12, right? Then we realised that must meant maybe. Well, the legislation is very clear. It's the employer must consult. So if they want to put their fingertips in their ears and go la 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 like some petulant teenager or 10-year-old, that's a matter for your employer. That doesn't change their obligations. They must have done the risk assessment. They must consult with the worker, in the singular, the worker. And then they must meaningfully engage with you. And under the risk assessments we are getting from Queensland Health and from others, they are outdated and don't deal with this particular intervention. Yet they're saying this intervention is about safety. Now, had they said it was about public health as opposed to occupational health and safety, that may be a different position they could have taken. But they have said it is about occupational health and safety. They have opened the door to the Work Health and Safety Act being relevant and taking it away from the temporary and narrow public health orders that can only apply in a pandemic.
I've got a question here. Someone posted some stuff about the Constitution, and someone else posted some other things about human rights, I think. Anyway, what is it? Is it anything else in Queensland you can discuss in that space, or are you keeping your powder dry?
Look, I want everyone to be very cautious about the concept of the Constitution. It is the movie Castle was a fabulous movie, very inspiring in a lot of ways, but it doesn't necessarily reflect your real rights. Your employer controls the property. So if you want to get to the Constitution, one of the fundamentals of a state-based situation is your employer controls the property and therefore is in charge. Your employer must therefore resource it in a safe and meaningful way. The occupational health and safety laws are very helpful. The Fair Work Act or the state-based industrial laws are very helpful. And then in the states that do have human rights laws, so that is not New South Wales, but Queensland and Victoria, there is a Human Rights Act federally that can be of assistance. So all of those work, but I would recommend that you don't rely on the federal Constitution as your great protector.
Okay, but there may be some other stuff in the pipeline, but we're not can't discuss that at the moment. Sorry, I'm between two questions here. Please explain what you mean by the worker needs to be consulted. Consulted in what way?
Well, the work health and safety laws are not ambiguous. That upon I'll get the law up just to make it nice and easy.
While you're doing that, I cannot get into your portal on my phone computer. It says I've logged in, won't let me go any further. I believe there should be a magic link that might pop up. Sorry, our website is doing funny things at the moment with high traffic, so perhaps try from your computer again, maybe in a different browser. Sorry.
So I don't want to bore you with legislation, right? But what the Work Health and Safety Act says is the person conducting a business or undertaking must, so far as reasonably practical, consult as required under this division and any regulations with workers who carry out work for the business. And then it provides some examples of when that needs to be, but the definition of consultation includes allowing the workers a reasonable opportunity to express their views and raise work health and safety issues, and critically to contribute to the decision-making process. My understanding is by the fact that the decision has already been made prior to consultation, that hasn't happened. And critically, again, when is consultation required? The one that is the most important is when proposing changes that may affect the health and safety of the workers. And the other one is when identifying hazards and assessing risks to health and safety from work carried out or work to be carried out at the business and undertaking. These words are must and required. I hope that answers the question.
Yep, that's pretty unambiguous. There's a question here about, can I join the teachers union from Melbourne? Will I get full benefits? Yes, you'll get all the full protections of a trade union if you join our national teachers union, tpaa.asn.au, I believe it is. You can find the website on the redunion.com.au. I apologise, we haven't got back to your queries about whether you can join from interstate. We are prioritising people with industrial issues at the moment, but there are so many questions from people asking whether they can join interstate. For those that are interstate, take it from me right now. Yes, absolutely. If you're a teacher, you are more than welcome to join the Teachers Professional Association of Australia. If you're a nurse interstate, yes, absolutely. You can join the Nurses Professional Association of Australia. Yes, we'll be taking on your industrial issues. You'll be covered. We will, in time, be able to negotiate enterprise agreements, etc. But obviously, please just give us some time to get through this very busy period. I think there is a significant issue in front of us that we need to grapple with. But from Christmas onwards, I would say we will be, more than happy to negotiate enterprise agreements in state.
Might be worth saying as well. AMPS is also for all medical professionals.
AMPS for medical professionals. Yep.
And I see a few questions coming back about when do I send the risk assessments. If you haven't already, you must. And yes, Rick, the law that I quoted there was the Work Health and Safety Act 2011, and the most recent section I quoted was section 49. There are harmonised national laws except for WA. And hello, Craig. Sorry about the WA variation there. WA's always like to not sometimes play ball. Now, I want to be real clear. If you have not already asked for a risk assessment, you must get out and do it today. You cannot wait. If you want to claim an exemption, you must do it by tomorrow. Don't keep your powder dry. Your protections come from coming out of the shadows. Your protections do not come from laying silent. And I'm sorry for being plain on this, but these questions about when do I do it, if you haven't already. And finally, and this is the one that's coming back more and more, about what if they don't respond? Do I escalate? You've just heard the legislation. It requires them to consult. Flicking it up the path, they've put this deadline on. They've narrowed the rules, and one party, who is your legal employer, being the Department of Health in the case of Queensland health workers, is directing the health service, which is a completely separate entity, 16 separate entities. Now, I need to stress, Scott Morrison was asked, would he make it mandatory? That allowed it to be put in the Fair Work Act, and they amended the Fair Work Act. They've done many amendments post-pandemic with the Fair Work Act. He said no, right? Would not do it. That means the employer has no cover. It must be an employer's decision based on their individual risk assessments. And don't take our word for it. The Fair Work Ombudsman has put some guiding positions, and they have even made a point, they're updating it frequently, about these mandates. So it is lazy and plainly BS in most cases to say that, oh, I'm just following the directive, right? Because the federal government cannot direct a private organisation how to conduct itself. Am I getting irritable yet at the at this? Am I coming across bad?
There's another point made here. Somewhere I've read that they've written that they have consulted with all the unions re this mandate. I take it this is a Queensland health mandate they're talking about specifically, and I think what you're probably referring to is the what are the act is they refer to in that mandate is the Hospital Health Act or Hospital Boards Act.
Yeah.
So I think there is a section in there saying that they must consult with the registered organisations, which they have done, I believe. Don't quote me on that because I wasn't in the room, but so yeah, I mean, I'd go so far as to say the unions are, not only were they aware of these issues, perhaps they're even have a question to answer.
Well, they're talking about section 51AA of the Hospital and Health Boards Act 2011. And it says that the chief executive must consult with the services or employee organisation about the issuing of the proposed health employment directives. Look at the page. The chief executive, that's Mr. Dr. Wakefield, must consult with the services or the employee organisation. So there wasn't even an obligation to have a chat to another one of the legacy unions. He could have just had a chat to each health service, and that would have discharged that obligation. But while everyone's getting excited by that and saying they don't need to do it, they might want to read the very next section on the page, section 51B, relationship with legislation. If a health directive is inconsistent with an act or a subordinate legislation, the act or subordinate legislation prevails. Well, the health directive is inconsistent with its own act. It's inconsistent with the Hospital Health Boards Act, and it's most certainly inconsistent with the Work Health and Safety Act and other acts. And I don't want to telegraph too much, but I don't take cover that saying they've had a natter with somebody else discharges their obligations to you, the worker, at a departmental and business unit level?
I've got a question here. Unions are hopeless. Well, I hope you don't think we're hopeless, because we're certainly working very hard. But there was a question about, are you still fighting for leave with pay? I think that is getting to the point of come the mandate deadline, locked out of the workplace, and your employer says to you, do not come into work today. Just because they tell you do not come into work today doesn't mean they can stop paying you. Is that right, Miles? If they've directed you to stay at home, it's basically like a direction to work from home.
If you've sat on your hands and you have not exercised any rights, if you haven't escalated the safety issues, if you haven't communicated your desire for an exemption, if you have done nothing, then you may be giving them the very ticket that you're most concerned about, right? So I can only stress, please communicate with your employer about any concerns with your occupational health and safety. Please communicate with your employer about a religious exemption, a medical exemption, or an exceptional circumstances exemption, and do so before tomorrow. If they then lock you out, it's a very different proposition to if you do nothing. I can't stress that enough.
And I must say that too. You know, we find out what's going on from you on the ground. So come tomorrow, if you're hearing further rumours from Metro, wherever, or any health, HHS, or even interstate in New South Wales, what's happening on the ground, what they're planning on doing, please let us know. Particularly even come the 1st, let us know as soon as possible. Don't think that don't assume that we will know what's going on. Please let us know what's going on early in the day. A question here: if we are on long service leave, should we still ask the risk assessment? Probably not a bad idea to do that, but maybe you can wait. If you're on long service leave until January, you probably don't need to deal with these processes until possibly after this has played out. Is there a template to ask for a risk assessment, or do you just ask simply? There is a template on the website, but you don't need to follow it. You can just ask simply. How do I know if we fit into the other exemption criteria as no patient contact or can work from home? I guess you'd have to, how do we know if we fit into the other exemption criteria? Such as, so if they don't come in with patient contact, is that considered an exemption? Or if they can work from home, could that be an exemption?
So the obviously different. I see there's questions there about whether it's a public health order, the employment health directive, or your employer directing it. So I'm going to try and give you as clean an answer as you can. Each site's going to have a slightly different approach, but obviously if you are not facing a patient and there's no directive that or the directive is focused on that will be a different set of circumstances. And I know you're probably all going to roll your eyes at this point and go, this is why we keep going back to the risk assessment. Ask them for what they've got. You might really like it, right? You might just go, oh yeah, that makes sense. I'm actually really happy with it. Or when they sit down and consult with you as the law requires, you might cut a deal that you're really happy with. So this is the frustration in this whole process, in that there are so many work sites. You know, when you're as old as me, when I started, you had lifting limits, you know, maximum of 32 kilos for men, and I think it was 20 odd kilos for women. And of course, you could have a bloke that was built like a 12-year-old stamp collector, and a lady that was built like Hulk Hogan, and therefore those things were stupid concepts. So what the Parliament said is, it's not for us to tell you how to assess risk. We're going to give you some codes of practice. We're going to give you some Australian standards. Off you go and assess risk. So the idea that then you've got an edict from up high runs absolutely contrary and completely counter to the concept that the person in charge of the organisation rationally assess risk while consulting with those impacted. But I'm probably saying like a broken record at this point.
Sorry, I've just I've replied to. I'm trying to send a message to everyone, but every time someone sends me a direct message, it defaults send. I've got some questions about people having trouble to. It's trouble finding the workplace health and safety info page. I've just dropped one in the chat there for NPAA, because it seems like there's a lot of people in the medical space. If you go to npaa.asn.au/WHS info, then that is the best. That has the templates there and steps through the process, gets you up to stage 4. We haven't got to stage 5 yet. Please, do we? Stay with us. You'll
Stage 4 is in everyone's, AMPS, NPAA and NPAQ's inboxes right now.
Okay, and please hold to further instruction.
Also, if you're looking for the step-by-step page, if you just go to that, your respective union, regardless whether you're a teacher or whoever, and you just add /WHS info onto it, you'll find the page.
Yeah, it should be on the homepage.
It is on the homepage as well.
Can it work from home? Okay, sorry. There's a lot of stuff coming, big questions coming through. There's a lot of questions of people saying, can we join? Just yes. I don't know how to be more clear than that. If you're working in the medical space, you can join AMPS. If you don't want to join AMPS, you want to join NPAA instead, you can join. I must just flag, you won't be a member with voting rights if you aren't a registered nurse, but you will be an affiliate and you will get all the same protections. The same price, you just can't vote or sit on the executive, but you'll get all the same protections. But again, if you would rather join AMPS, join NPAA if you'd rather, or even the TPA if you're a teacher. If you're in New South Wales, yes, you can join. If you're in Victoria, yes, you can join. If you're in WA, yes, you can join, and we'll be able to assist you with these matters. I'm a teacher in Victoria. I have not yet received anything from my employer. Do I wait until the first email or contact to act? I feel that I can't send anything if they haven't requested anything yet. Please advise. If they've made it mandatory in Victoria, and forgive me, I have been focusing on Queensland with the imminent deadline, but if they have made it in Victoria, I'm not sure that they have, but if they have made it in Victoria, then I'd be requesting a risk assessment, absolutely, if you're concerned about the risk.
Probably worth saying as well, parts of the website as well for stage 3 and stage 4 aren't available for other states yet. Those step 3 letters will be made available as the mandates appear in those states. So if you can't find them, don't panic, they are coming.
Someone said, I'm an IT professional, can I join? Yes, you just be an affiliate with either AMPS or NPAA. Over to you, whether you'd rather fall under the jurisdiction of doctors or nurses. The Telegram, Tracy, is
ME.
ME?
Yeah, oh, so hang on, I've got it here. T.me /ME /NPAA
NPAA
001.
0001 0001.
No, 2 zeros and a 1.
201. Okay, I've got that wrong in the past. but for those looking us on Telegram, if you just go to Telegram and you search NPAA, we should come up as well.
Okay, I'm sorry. There's a bunch going on exemptions, and we'll repeat it. I need to be really clear, right? We'll deal with them one last time. And I'm stressing in the firmest possible language while still trying to smile, you can't make up an exemption. So from the beginning, if someone said, oh, religion is an individual thing. No, it's not, right? And if you do that with your employer, they're going to likely say that you're acting in bad faith. If your pastor is going to sign off on it, it is consistent with your faith, and only if you know your pastor would be prepared to go to court on your behalf and say so, should you apply for that religious exemption. Or when I say pastor, I mean whatever religious leader, right? So please don't game the system. It's bad faith and you'll get in trouble. Secondly, your doctor will determine your medical, if you are exempt on the basis of medical, right? There are the terms there, your doctor is well aware of them. We can't give dictation to our treating doctor, right? So only your doctor can determine that. And if your doctor certifies that you are going to be meet the criteria for what is an exemption, it's generally referred to as a contraindication, but not exclusively, then your doctor will determine that, right? And I need to really stress that. The third area of exemption is special circumstance. Special circumstance has not otherwise been defined, and it's not in every state area. But please, if the criteria opens the door for special circumstance, it very well may be that your quest for consultation could trigger a special circumstance, and there'll be some more materials up there. But please know that it must not be gamed. The system, it's got to be good faith requests.
Question here, do we ask if we're on the roster? So I guess we might just round this up quickly. I think most of the questions that are coming through now have been are already answered. So we will be putting up a recording of this. So advice you would be go back through this and rewatch it, and you will be able to pick up on questions that have been answered. So do we ask for on the roster? So I guess that comes into the question of, you will need to ask your boss, are you coming to work on the 1st? So you need to clarify, am I coming to work? If they say, no, do not come to work, that's a workplace direction, you don't go to work. You need to comply with that. If they say, yeah, come into work, well, then that's a different story. You've complied with your boss's direction. Admin sort of stuff. I'm in New South Wales, excellently joined NPAQ. Can I be transferred to NPAA? Yes, of course you can. Unfortunately, that probably won't be prioritised at the moment because we're dealing with imminent deadlines. But you know, possibly it won't matter too much. But in about a month's time, we will get to our housekeeping, get our house in order once we've got through all of this. One last lucky dip question. If there's anyone that's got a burning question.
We'll get the recording up. Jack, can I answer one? Can I throw one out there? If you are good faith applying for those exemptions, there's no trickery, right? There is a trick if you were to be tricky, forgive the pun, right? Please understand, if you've got an exemption, you should apply for it. And now speaking directly to Queensland Health employees, you must apply before 11:59 tomorrow, and you must do so by notifying your line manager as well. Now, please make sure that you are acting in good faith if you're applying for it. Now, we think that the test for special for an exemption with relation to exceptional circumstances has been triggered by this process, and the team's going to publish a document shortly that will deal with that. So you should keep an eye on that. And Jack, how will that be coming out?
How will that be coming out? Sorry, I was reading the question.
So was I.
Sorry, yeah, say that again.
Extension document. When's that?
That has been,
I'm doing that after this meeting.
So there will be something coming through shortly.
Yeah.
I see Romano's angry at us for not seeing his question. Look, I am terribly sorry. We don't have unlimited time resource, but if you want to ask a question, again, Romano, I will try and get to it. But okay, here it is. Would we not be helping Queensland Health by falling for their trick with the exemptions? All putting exemptions in is going to do is give Queensland Health time to hire people to replace us. They replace how many staff they are going to lose. So they made a point, email the exemption in the hopes that we will have our exemptions tonight once they go back staffing up. And at the moment, we have shift something. Can I just quickly before I throw to you, Miles? I'd like to say there's been a hell of a lot of nurses that have left nursing in the start of the pandemic who are all casuals. The casual pool has been massively dwindled when they stopped giving out shifts for like 3 or 6 months. Nurses went, people just got different jobs. So I don't know how they're going to do that quickly. That would be a.
I want to address Romano and Romano head on. And if you're the concept that an employer would see so many talented people leave for a month's worth of role to gear up for someone else doesn't reflect the power of the talent pool that they've spent their time growing and raising. Overall, the employer does a pretty good job. There are always things that can be done better. The concept that they are going to trick you into doing this, right, reflects what happens when edicts from up high with short time frames happen. It erodes trust. But Romano, that makes no sense from a practical point of view. What are they going to do? Get people in, get agency people, gear up? That's not the issue, right? This is that I expect most of your line managers, first up manager, director of nurses, etc., are devastated at the idea that this edict has come and having to follow it along. But I respect that you're saying that you've lost trust and that you think there's a trick. There's no trick. It's a stupid direction that was done without consultation. It's being fought in the Supreme Court. It's being fought at a ground level. If you've got a right to an exemption and you're acting honestly, then we'll apply. If you're acting dishonestly or acting in bad faith, don't apply, because the trick is lying about an exemption.
Thanks, Miles. Someone just said Channel 9's about to put us on the nurses thing. So unfortunately, we have to go because we have a lot of work to get through tonight anyway. I know we've missed so many questions. We will be scraping the chat, and perhaps I'll get Tracy on doing an FAQ for some of these questions in the Telegram, and people can see them there if they would like. But Miles, thank you so much for your time. You've been amazing. Yes, Miles. Right.
Questions come up about 50 times from the same person. Don't rely on your previous exemption, right? And the idea that you got a mask exemption gives you another exemption. No, that's not what happens, right? So you've asked it about 50 times. I want to be plain here. You know that you're putting yourself in a bad position by doing that. You've been told to put your exemption by 11:59 tomorrow. Sorry for being a pain in the ass. We know the rules. Let's not play games and say, I've got a tick in this box, not do it. Exercise your rights while you can. The last thing we want to do is not come out of the shadows and have the boss treat us badly. Sorry for the plain speaking. I promise to shut up now.
No worries. Thank you so much, Miles. Appreciate your time. And everyone else, if you do have colleagues that haven't been able to join the Zoom or aren't a member, and they do have concerns about, workplace health and safety, I would get onto them and give them a wriggle on to get in start on that process, right? Even if it's just the first one. Recording, we have put up the past couple of recordings up on social media, I believe. I know the first one was, the second one might still be coming. This one as well. We might even see if we can throw it up on Telegram tomorrow.
Probably email that to people as well.
Yeah, we'll see what we go. I think someone was working on putting them up on YouTube. I know they're on Facebook, on the NPAQ Facebook. But anyway, thank you so much, Miles. Thank you everyone for tuning in. Really appreciate it. We will keep in touch with you. And I understand it's a very stressful time for all of you. I know it's certainly a stressful time for us, but definitely not as stressful as it would be for you guys. We're not looking down the barrel of losing our jobs, but we are certainly taking on the responsibility of trying to save your jobs, and to help you out and to make a safe workplace for you all. So that is no light burden. But thank you all, and we will certainly keep in the loop.
All the best.
See you guys.